NACDL is the association of the nation's criminal defense bar.
Hello and welcome to QLE, Quarantine Legal Education. It's Credits Without Contact is what we're calling it. I'm Laura Sheely with Pocket Expert Forensic Consulting, LLC. And this is being brought to you, I'm your host, and this is being brought to you by NACDL. Very, very appreciative of NACDL trying to get CLEs for all the lawyers out there amidst this horrible, horrible pandemic. I did not have a lot of the technology needed to do this, but over the last week, since my last guest was here, Tiffany Roy, I was able to get some sound effects. I'm super happy about my sound effects. So this is the introduction to our, well, actually, I hope that you're not going to ever hear this sound effect. That would be me bombing on this show, and I don't want to do that. But without much further ado, I know you all want to get started and get the information that my next guest has to offer. Miller Leonard is a lawyer out of Golden, Colorado, and I am going to welcome him to our show, and he's going to have a presentation for you. But before that, we're going to talk to Miller a little bit. But Miller!
Hi, Laura.
Welcome to Credits Without Contacts.
Thanks for having me.
Very much appreciative of you being willing to help out in this horrible, horrible time. Now, out in Golden, you are a criminal defense lawyer, correct?
Yeah, I do. I do criminal defense in Golden and Denver and the Denver metro area.
I think what would be fun is, us experts are always in the hot seat up on the witness stand. So I guess what I'm going to do is I'm going to qualify you.
Oh, all right.
So if you could please state your name.
My name is Miller. That's my first name. My last name is Leonard.
And your experience and training to be in this field?
I started my legal career at Legal Aid of Western Missouri, where I defended individuals who were charged with violations of what would be in most cities misdemeanors. And in court, I moved from Legal Aid to the Missouri State Public Defender's Office in Kansas City. It's the largest trial office in the Missouri State Public Defender system. Excellent training, excellent people, just a wonderful system. From there, I became a state prosecutor and a special assistant United States attorney. And then after about 6 years of government work, I moved into private practice, and now I own my own firm.
That's awesome. And your firm's name is Leonard Miller PC, correct?
Other way around, Miller Leonard PC.
I'm sorry. Miller Leonard PC, and it's millerleonardlaw.com.
That's correct. Yeah.
But today you did an excellent job qualifying yourself. I think most judges would say that you're allowed to continue. Today you're gonna give us a presentation on legal writing, correct?
Yeah, it's legal writing from the trial lawyer's perspective. And to make it clear, this is not appellate writing. I don't do a lot of appeals. This instead is, practical pointers for lawyers like myself who go to trial, who appear in front of trial court judges, and who need to impress upon the judge the idea that we need the judge to understand.
I know that I get, as a scientist, I'm not a writer, and I get very, very confused with, not confused, maybe frustrated, with how, indentations are important. And that
Yeah.
may be more of the pellet and PC world, but the pickiness of it, even if it is a great claim, if it's not written well, it's just not going anywhere.
Yeah, that's correct. Yeah.
And I'm just I to me, but that's coming from a DNA expert, right? A crime scene expert. That it seems ludicrous, but it is so. I have learned over the last 25 years that it's so very, very important.
Yeah, I think writing is underestimated, and especially from the trial perspective. In the criminal defense world, most lawyers started like I did in areas that were non-writing intensive. It was more courtroom, on your feet advocacy, and that's important. And those are great skills to have. But what I've found in my career is, as I've moved into more federal work and more complex cases, that the ability to write has become more important, and the need to effectively communicate with the court becomes more important. And understanding how the court receives our pleadings, our motions, and any of our written material is crucial for us to become excellent advocates for our clients.
In my experience, and as an expert, not as a lawyer, obviously, I have found it truly crucial for the lawyer to not only be willing, not only be able to write, but be willing to write. The motion in limines, right? The Daubert motions.
Right.
I see those so. Those are very much a part of my field, especially after the PCAST report, the 2016 PCAST report, the 2009 report on strengthening forensics, talking about the essentially junk science, or science that actually needs to go through the scrutiny of the court. And that can, if it's not written to where the judge understands the point that you're trying to get across, all it really takes is a prosecutor to stand up and say, DNA's been accepted for 20 years. What the hell are we doing here?
Right.
This should just be thrown out.
Yeah, that's a good point. I mean, the art of writing is going to be to take something complex like DNA or the junk science you're talking about, and get it so that the court, one, will pay attention, and two, will understand the issues. And there are some skills that we can employ to help the court understand the point we're trying to make.
And is that some of the stuff that you're going to be talking to us today about?
It is, yes.
Awesome. Well, I really look forward to it. But before we go on, there was something that I meant to say before we started, but I'm going to say it now, since no F-bombs have come out, or we haven't started talking about anything. And I don't think that we're going to hit on that with your presentation today. But for the series, I've noticed that Netflix and Hulu, since I'm watching a lot of Netflix and Hulu right now, are giving warnings. I mean, they're even warning if somebody vapes in the show.
Yeah.
They're saying, vaping, bad language. I don't think I'm going to ever have to say that nudity could be shown on our web series, but I will say sometimes it's probably not a CLE that necessarily needs to be shown in the presence of children, knowing the kind of topics that we talk about and the kind of crimes that we're talking about when we're speaking about criminal defense.
Sure.
So I just wanted to throw that out there, and before your presentation, what's going on in Colorado? I mean, we're in Arizona. Are you having any trouble getting anything?
No, so far, thankfully, we're not.
How is everybody pretty much staying at home?
Yeah, I think that people are pretty much staying home. There's a lot of people running, walking, and going outside.
Well, and then I'd also like to address that this is very casual, and so we're both in our homes, and I don't know about you, but I've got cats running around that could jump up at any moment, and I just want to let our viewers know that this is not a studio that we're at, and any noises of garbage disposals or cats running around, that's to be expected right now because everybody's at home.
Yeah, exactly.
Have you been doing anything to keep yourself occupied other than just working?
I like to run and work out, so I've had to change my workouts a little bit since I can't go to the gym, but otherwise trying to keep a normal pattern.
Well, I've still been getting cases. And that's great. So I've been able to devote a lot of time to my cases. I know just today I've gone through 3 books, and my God, coloring 3 books is excruciating on my hands. Run out of all my crayons going through 3 books that fast. But seriously, I'm going to let you get to your show without any further ado. And I just want to say that I asked for it when I had Tiffany Roy on last week, and I'll ask again for any of our viewers that are enjoying our series, that whoever has a Flowbee, please send it to me. And so let's see. I don't want to put these to waste. So hold on. Without any further ado, let's do your presentation, Miller.
All right, perfect. And if I hit share, will the PowerPoint come up?
Yep.
Okay.
There it is.
Perfect. So this CLE sort of started off in a CLE that I gave to the First Judicial Bar Association, which is in Golden, Colorado. And the idea was, how do we, as lawyers who appear in trial courts, effectively engage in legal writing? And the first thing that we all have to realize, and it seems pretty academic, I suppose, is that lawyers, we primarily are writing for judges. That's the audience that we, in general, are wanting to persuade, inform, and educate. And so part of what I did before I presented this CLE was I was fortunate to be able to go talk to a number of sitting district court judges, a retired county court judge, and I can also bring my perspective as a part-time municipal judge. And what I noticed was, just through my observations, is that judges seem to be, at least in Colorado, really overworked. And in Colorado, there's some statistics to back that up. For instance, I believe in our judicial district, we have about 77% of the allotted judges that we should have. So that's a tremendous, 23% shortage of judges. In my own practice and in my time on the bench as a municipal judge, what I noticed was that when you get motions to read, you're tending to read them in between dockets and other matters that are going on in the court. And that was confirmed when I talked to the district and county court judges. And so the first thing is that the judges just don't have enough time to read our filings. And that's unfortunate, but that's a reality. And knowing that the judges don't have enough time to read our filings, we have to do some things to make our writing more easily understood. And we have to write in a way that will capture the judge and make them at least want to continue to read our motion and understand it. The second thing that really struck me, and that I've noticed when I've been reading motions from the municipal court, is that judges just don't know the cases. They don't know the cases factually and legally the same way the participants do. There's a lot of reasons for that, but primarily the reason is that the judge has a case file in front of them that consists of charging documents and filings by the parties. What they don't have, and what they don't go through, is the discovery and witness statements and everything else that we as lawyers and you as an expert lawyer that go through. And so they don't have the same base level of knowledge to understand what it is you're going to file and want them to read. And when you think about a judge, reading motions is just part of what they do. And ruling on motions, they have a lot of other things that go on. And this is never seen when you're in court. But when the judge leaves the bench, they go back, and he or she is going to engage in a lot of back office business, which is signing documents that need to be signed that are sort of perfunctory, like a bench warrant. But those add up, and so they continue to pile up, and the judge has to clear them out. The other thing the judge is doing a lot of is that they're answering questions. And so you're constantly being interrupted as a judge, because court personnel, clerks, and other people are coming to you and have questions that you have to answer. And finally, it's when we're writing, we need to understand what kind of court we're dealing with. And for my purposes, there's 4 courts that generally criminal practitioners are going to deal with: a municipal court, a county court. In Colorado, that's where misdemeanors are heard; district court, which is where felonies are heard; and then in federal court, where you can't have misdemeanors, but most of the time you're going to have larger matters. And so it's important to understand what judge you're writing for, because each of those judges has a different workload and a lot different support network. At the county court and municipal court, there's no law clerk. So there's nobody that the judge can assign a large motion to. These are more like triage courts in a lot of ways. It's very quick. At the district court and state court, you're going to have more resources and back. Maybe, depends on where you are, but they probably have one law clerk. At the federal level, they have a lot more resources. And so when you see that in federal court, that the ability to have career law clerks or really smart individuals who are clerking for 1 or 2 years. So it's important to understand who you're writing for.
With that being said, I apologize, but let me interrupt you for a moment. With that being said, could it also, and this is just a question, could it also be important if you're in a county to get to know a specific judge and what they like? I mean, it's know your audience, right?
Yeah, that's absolutely true. And I think that the local bar associations can play a big role in that. And I found that the judges in the First Judicial District were really willing to talk to me about what they liked as writing, because if they can get that information out, it makes their job easier. It's harder, I think, to talk to federal judges just because the nature of their position is a little bit more locked away from the general bar.
And maybe their law clerks, though, would be to seek out or reach out if possible.
Well, I think law clerks are always good. And in federal court, you're always going to see that they have their own rules. You've got
absolutely.
Each of them have their own little rules on what they want you to do. So it's important to go check their rules, because some judges will say, I want every motion in 12-point Arial. And it better be in 12-point Arial double spaced, or they're going to kick the motion back and say it didn't comply with the rules. So
I've heard of some of the attorneys that I'm working with that, the judge wants 14 pages. And if you go over 14 pages, nobody's looking at it. It's gone. It's history. And, that has taken people that I have known weeks and weeks of trying to get all of their points so consistent that I mean, 14 pages when you're looking at these cases that are, 10, 15 years old, that's not a lot. And yeah, I don't know what font, but I know that there was in that particular case that I'm thinking about, there was a specific font. I don't know if it was Comic Sans or whatever, but I mean, it to me as a scientist, I just couldn't believe the limits that were being put on the lawyers. So that was crazy to me. And
Yeah.
and 14 pages, and then does that include the signature line? And so that was just crazy.
And I see that a lot in federal court. I see a lot of judges who will say, 15 pages, and they'll be specific and say that doesn't include the signature line. And if you need more, you're going to have to file a motion that lays out for the court why you want more room to write. And so in big conspiracy cases in federal court where you've got Title III wiretaps and a lot of information to go through, it's not uncommon to have to go to that judge and say, I'm going to attack these wiretaps, and I need more than 15 pages because the wiretaps went on for a year and a half, and there's just no way I can get the volume of information I need into 15 pages. And I've also seen judges say, well, that's fine, I'll give you up to 35, but no more. And I think part of why you see that, and you see that in state court as well, goes back to point 2 here, is that they don't have enough time to read our filings. So they're trying to compress their own workload by getting us to write less. And perhaps also it's a signal to lawyers that a lot of our writing can be narrowed down and more focused, and that we can get rid of a lot of the verbiage that we use that's really irrelevant. And that's why I pulled this quote from James Smith, who's an Arizona Superior Court judge down from your neck of the woods. And one of the things that he's big on is get rid of the sort of perfunctory legalese introduction. Instead, go right to the point of what you want him as the court to do. He gives some examples here. The court should exclude defendant's economist, Dr. John Doe, because his regression analysis is unsound. Or defendant is entitled to summary judgment because plaintiffs lacks admissible evidence to show that defendants fixed prices. I think this is important to remember. What this judge is saying is, I don't have enough time, and so why are you spending my time beginning to write with plaintiff by and through counsel, respectfully request the court to strike X, Y, and Z. Get to the point, tell us what you want, and then we can flow into the rest of the body of the writing. And it took me a long time to get rid of the legalese in my own pleadings, but I think it works a lot better if we do that.
I would think that is so drilled in to all the lawyers that are practicing and have been doing legal writing for years and years and years, that it would be extremely hard to try to change that, but possibly completely necessary.
I think you're right. And in fact, when I gave this presentation to the First Judicial Bar Association, one lawyer just stood up and said, well, wait a minute, can we do that? Are we even allowed to do that? And that's a really interesting question, right? Because we've done it for so long, we think that's how we have to do it.
Right.
And yet there's no rule, at least in Colorado, that says that's how we have to write these pleadings.
So have you gotten, and maybe I'm jumping ahead too much, but have you gotten any resistance by doing it this way from any of the judges that have seen your motions kind of revamped or renewed, I guess we should call it?
No. In fact, what I found was that almost every judge is like Judge Smith, that they really want the lawyers to do away with the legalese. They want plain writing. They don't want you to engage in writing that has a lot of Latin in it, like some pleadings do. Get rid of footnotes. Make it something that's easy to read. so that they can track along and answer the question that you're asking them to. And every judge I talk to, and I think this is just pretty much universal, they want to get it right. And what they're saying is, if you make it easy for me to understand, it's a whole lot easier for me to get it right. Whereas if I have to sift through your motion to figure out what you want, then it's becoming very difficult. And judges are human, so then they become frustrated. And if they're frustrated and can't figure out what it is you want, I think you're much less likely to get the relief you're asking for.
That makes complete sense to me anyway.
The judges that you're going to see next year they're all from the First Judicial District. And I think, though, that if you went to your judges in Arizona or whatever state that you happen to be in, you're going to find this is pretty much similar. That they, as Judge Zinasek, he wants the writing to be simple and straightforward. And he makes this point, and these are his exact words: to have this job is to constantly be guzzling information. And that is really, to me, that's valuable information, because now I can put myself in the position of a judge who's telling me I've got too much stuff coming at me. And
I'm choking
right.
is basically what he's saying.
Yeah. And if they're choking, and you're right, then we have to figure out a way that what we put in front of them doesn't seem like more of just this verbiage and meaningless drivel. And we want to write something for them that they actually enjoy reading, to the extent that legal reading is ever going to be terribly enjoyable.
Sure.
And Judge Zinasek makes a point here. He says, if I got to sift through 20 pages to figure out what you want, you've made my job much harder. Well, that's, I think, a polite way of saying you're not going to get what you want, right? Because if you can't figure out what somebody wants, then it's very hard to get the relief you're asking for. He likes people to get down to correct law, relevant facts, and let the judge apply it. And that goes back to the whole time thing. The other thing in Part D here is that he wants meaningful conferral, and every judge I talked to would bring this up with me. If you have a motion that you're going to file, talk to the other side. And don't just say to the court, I sent an email and I didn't get a response. Actually reach out to them. Talk on the phone. They realize we probably can't, especially now, get together in person, but they want there to be some sort of meaningful conferral. And that makes sense, because if the motion is unopposed, it's a lot easier for a judge to issue that ruling, or if there are parts you agree on, those are things that you're taking off the plate of the judge, right? He or she doesn't have to deal with those issues. So that's a big deal. I've had some questions about, well, what do you do if a lawyer doesn't get back to you? And I think you have to spell that out. And then I made 2 attempts to contact this person by phone. I left messages. I told them when I'd be available. I didn't hear from them. I sent them emails. I haven't heard. So now I'm moving forward with this motion.
If you do confer, and everybody viewing may just laugh at me for asking this, but I'm just going to ask it. If you do confer with the opposition, and you agree, it's still important to make sure that it's on the record via some sort of writing, is it not?
Sure. And so, when I confer with the U.S. attorney and they agree to my request to get rid of GPS monitoring for a client, then I'll put my motion. I conferred with the assistant attorney assigned to this case. They have no objection to the court removing GPS monitoring for this client.
Perfect.
I don't think you have to do more than that. But I think it's helpful. And the judges, they want it. And since they're who we're writing for, it's really important. And in the civil context, there are just rules you have to confer. It's not as much in the criminal context, but I think it's good practice to confer on the criminal side as well.
Do you think that you would confer on all of the motions that you're going to write? Because I know a lot of lawyers don't want to, some of the motions may give some perspective on their case in chief, and they may not at that point in time want to share their perspective of their case in chief until they're ready to actually just file the motion.
Yeah, I think that's right. So I think that especially on the criminal side, the conferring component is going to be contingent upon whatever motion it is you're filing. I see this most as the judge wanting us to confer when it's an evidentiary request. So if you're fighting over what evidence should be released, then the judge wants you to recite that I talked to the assistant United States attorney or the district attorney about getting this evidence. They agree or disagree. And that way the judge understands. But I think, theory of defense, substantive motions, there's constitutional reasons why we might not even want to release that information. We may not be able to release that information until we file that motion.
Perfect. But like what pictures are coming out in trial and that kind of stuff. Absolutely. I get that.
Right. Exactly. Judge Tai, who's a district court judge in the First Judicial District, one of the points that she makes that is something that everybody who's engaged in legal writing needs to really incorporate. And this is, she likes headings to say what the motion is about. And headings are really important when we write because first off, it's going to tell us what the motion's about. But then we're going to have subheadings as we write that transition the judge along the way as to the different parts of our motion. So it's really important in a lengthy motion to have both headings and subheadings. And Judge Tai, like Judge Smith and Judge Zinsek, she's really big into readability.
She kind of likes the outline.
Right. And you'll see this as a theme in writing, is that the outline is important. And again, when we go back to the judges are overworked, Judge Zinsek says, I'm basically swimming and choking in this information. Well, the outline's going to help us. A short background and procedure section, Judge Tai says, is important. And that helps orient the court. And again, it's important to put that short background and procedure. We don't need to put a lot, but we need to put some, because when that judge picks up the file or gets it on their computer screen now, they don't have the same amount of information that we as lawyers and parties have. They haven't looked at the same information. So you need to orient them as to what is this case? What's happened in this case? And then you can move on. Judge Tai really likes bullet points, and that's another thing that we need to incorporate, all of us, into our legal writing, is bullet points. Because again, it's kind of keeping it simple. There's this fact, this fact, this fact, and we're bullet pointing them out. And that makes it real easy for the judge to read. It helps them track with us what we are trying to get across. And we're engaging them to want to continue to read, which, is important because, again, I go back to Judge Zen. It's like, if I'm drowning in information, then it's going to be a relief if I get a well-written motion to read, because it's making my job easier. The other aspect that Judge Tai brought up, which she specifically was talking about domestic cases, but it applies in criminal cases as well. Use forthwith, or don't say this is an emergency unless it really is an emergency. Because what she was saying is, look, if somebody tells me it's an emergency, I'm going to get on that motion. But then I'm really upset. These are my words, not hers. But
right.
What I think what she's saying is, I'm upset if I get into it and I find out this could have waited, right?
It's not an emergent situation, and yet you've red flags have gone up because you used the wrong vocabulary.
Right. Exactly. Yeah.
And therefore, you could get penalized for the use of that and upsetting her.
You definitely can. And I think
I'm not saying that she would take it out on the client. I'm just saying that gee, that could be a possibility. I think we've all probably seen it happen.
right. I think judges keep score just like lawyers do, right? We all know the judges that we like or dislike and judges that give us a hard time. And I'm sure that the judges do the same thing. And if you don't want to be the lawyer who is crying wolf, that's, you want the judge, if you're saying I've got an emergency, well, you want it to be a real emergency. So they actually will pick your motion up and give your client the relief you need them to give. Judge Pilkington, district court judge, and he's covers a lot of the same things that Judge Ty and Judge Zinnes did, but I'll come to this a little bit later. He really likes pictures and diagrams, and I would encourage lawyers to put pictures and diagrams into their motions because it engages our sight. And it's another way that we obviously all get information, and it makes that motion more understandable, especially in the criminal context when we are dealing with oftentimes motions that involve a location, right? I mean, if we're talking about blood spatter, which is your expertise and not mine, a picture of what I'm talking about is going to be much more easily to understand than the written component than if I just write it, correct?
Absolutely. I'm smiling a little bit because I'm thinking about, a lawyer saying, okay, the prosecution thinks this happens with two little stick people and one little stick person shooting the other. But this is our view, and it's two little stick people, arguing. But I understand that that's not what you're saying. But absolutely. And getting the right pictures to utilize is very important, and just kind of breaking in there with your thoughts on blood spatter or crime scenes or anything. I feel very strongly that when you're working on the motions, get your expert's opinion.
Definitely,
Utilize your expert, not just on the stand, and don't talk to them until it's time to call them for trial, and that you haven't talked to them since you sent them the discovery a year ago, and then you expect them to get up and testify. Use them on these types of issues too. Hey, Laura, what's the best picture to show what I'm trying to do here to the judge, to help explain it to the judge? Or what's even analogies, right?
right.
Use your expert because they've come up with that. They're involved in the case. They're going to know what is going to be most helpful to another individual to be able to understand what you're trying to say in your motion. Now, I'm not saying an expert in any way could write a motion. Not most experts, at least not this one. But certainly I've been involved in helping with motions on so many cases that I could never keep count. But I think that's a invaluable use of your expert is to let them help in the participation in wording, and as you bring up in possible diagrams or other types of documentation than just the written form.
Yeah, I think that's right. And we need to remember in the context of experts, think about how much time it takes us as the lawyer to understand what the expert's trying to tell us. And now we have to take that and present it to a judge who doesn't have the ability to sit down with the expert in the same way that we do. And so we really need the expert to help us, to teach us, to convey with a point that they're trying to make, that we need them to make to the court in an understandable manner. And you're doing your client a disservice if you're not using your expert in that way, like you just talked about.
Well, and I also think judges are they have the ability to get special masters, and that they have the ability to get and we saw it used most recently in Michigan and New York on the software called Trueallele that is population type statistics. It's a genetic statistics software that they're using in many states, but the judges actually got their own experts, which I was very, very pleased to see. And I would hope that more judges would do that in a forensic heavy case, be it DNA, whatever it is, that judges become more susceptible to hiring experts or getting an expert to help explain what this motion means, or what are they asking for? Does this even make any sense? Or help during trial. I mean, I know that that's what the both sides experts are trying to do, but at the same time, the judge has access and the ability to have their own expert. And we've seen it used recently, and I would love to see it being utilized more by the judicial branch or the judiciary.
It's a good idea. One of the things that when you're sitting on the bench, even in a simple municipal case, is that the parties start presenting the case to you and you don't understand it. And they think you do, but you don't understand it. And that's a sort of a lesson for all of us to, as we're advocating for our clients, that we need to think about the fact that we often say in court, well, as the court knows. Well, the reality is the court doesn't know. And they probably want to know, hopefully.
Right.
And so it's our job to educate them. And that's a good point. When we talk about educating, Judge Fish, who's a county court judge here, she was talking to me about, and she just retired, but she's like, look, I'm at the county court level, I'm busy. It's basically dockets all the time. And these are your misdemeanor dockets, order protection hearings. It's sort of the people's court. And so she's like, just get to the point. I want to know what's relevant in your case and give me the case law that's on point, because that's the bandwidth or the time frame that I have to look at your motion. And a lot of times we, as lawyers, will spend a couple of pages before we get to the relevant point in the case law that's on point. And her lesson to us is, no, get it up to me right away. Get it in front of me right away so I can make my motion ruling for you, and we can move that case along.
Yeah, I've seen where the lawyer will send it to me and say, yeah, just skip to page 9. And, I'll skim over the first 9 pages, and it is all, to me, it all seems irrelevant because the issues don't start until page 9.
Right.
I'm like, wow, there's a small tree. Not so much anymore because it's electronic, but I get that, and I get why the judges would not want to have to do that either.
Right, because nobody's telling the judge skip to page 9.
Exactly.
So you don't want the judge to have trolled through 8 pages, 9 pages, and then maybe they're bored or maybe they're tired and they miss the crucial point that you're making on page 9, right?
Or at page 8, somebody comes and interrupts them, and that's the end of it, and they haven't gotten to the important parts, the parts that you're actually addressing.
Yeah, exactly.
And the other thing that I see with judges, you say that they want to be educated. I find that to be extremely true. I get called in for motion hearings quite a bit. And a lot of lawyers, whether they're going to need me or they, well, how do I put it? A lot of lawyers, to be prepared and to be able to make an excellent record, will have me at a motion hearing to testify And if I'm not allowed to testify for some reason, then I am often called up for an offer of proof.
Right.
And to have your witness, yeah, it might be a little bit expensive to fly me out for a day, but it's a invaluable necessity when it comes to maintaining your record.
Yeah, exactly. And we have to, in our writing, in our presentation to the court, we have to make sure that we're educating whatever party it is, be it a jury or a judge, about our issues. And we have to make it understandable for them. And it's kind of elementary, but when we write and we need to educate the judge, we're going to have to tell them who, what, when, where, why, and how. And that seems really basic, right? But how much legal writing have you read where those simple questions either don't ever get answered or they get answered in really long prose?
And I'm sure judges are used to it because they're not coming from my background, but they get lost. The who,
Right.
what, when, where, and why. By the time you're finished, your eyes are red. You're putting Visine in, and the point is potentially lost on them.
Yeah, that's exactly right. And that's where you don't want your judge to be, is lost. You don't want your judge to be struggling as they read your motion to understand your issue. And if there's two things I would tell anybody who's watching this that they should do to become a better legal writer, it would be to go by the book Point Made and Point Taken. These books are written by Ross Guberman. Guberman is just a fantastic legal writer and trainer. He trains all the new federal judges. He works with Supreme Court justices. In his books, he's going to give practical suggestions. So he's not just some guy who's really smart and a great writer. He's going to give practical suggestions to those of us who are in the trial trenches on how we can make our writing better. And for instance, he gives a list in his books of 135 different transition words, so that we're not always using furthermore, therefore. He
forthright.
Yeah, exactly. He's gonna give really good examples of how we can transition our ideas in a way that it's understandable. And he's got his own software he's developed that has a credible scoring system, and you can buy his system. It's called Brief Catch, I believe, and it'll actually just take whatever you've written and catch errors and make a lot of different suggestions. But he also points out that, contrary to what we've been taught as lawyers, good writing isn't academic. Good writing is easy to understand. It uses sort of plain, normal language, and it flows, which is not how, for instance, a law review or her article reads. And so I think
$15 words instead
right.
of quarter words. Right.
Yeah,
right.
Exactly. So I encourage people to buy those books. If you're on LinkedIn, you can follow Mr. Guberman. And that's something that, 20 years ago, we wouldn't have had that opportunity and that availability. But he'll post on LinkedIn snippets of good legal writing and snippets of briefs that he's analyzed and how you can write better. And he's made me a better legal writer, so he can make anybody else a better legal writer as well.
Are his books available on Amazon?
Yeah, I think they are. I think that's where I bought them from.
Okay.
And the funny thing about his books too is that when I bought them, I'll confess I thought, well, how exciting are they going to be to read? And they kind of read like a novel. I just blazed through them and thought, wow, I wish that my law school had taught me what he's teaching.
So a quick read and a good read.
I found it. So to me, his books are, the equivalent of McCarthy on cross-examination. they're just that good. And there's something that I've got a copy of McCarthy on cross-examination. I think every trial lawyer should have that. I think it's crucial. I think if every trial lawyer should have Ross's 2 books, because you will just become a much better legal writer. And if you're an appellate lawyer, you're going to just eat it up. But trial lawyers, it'll actually teach us something as well.
Do they have any, does he have any coloring areas to color pictures?
None of that, no.
Ross Guberman.
Ross Guberman, yeah.
Okay.
Yeah, he's on LinkedIn. You should follow him too. I know you're on LinkedIn, and it's just, he's fantastic. So I highly recommend that the people get into his work and follow him.
I'm actually familiar with the McCarthy on cross-examination. I haven't read the book, but I know I know lawyers that practice that very well, solely, really, and are very successful with it.
Yeah, I mean, I think McCarthy on cross is sort of the McCarthy and Posner and Dodd are the gold standard of cross-examination. And
isn't Posner, aren't Posner and Dodd takes on McCarthy?
Probably, yeah. I mean,
I may be wrong. I don't want to upset anybody, so I apologize if I'm not right. I'm a forensic scientist. What are you going to do? I'm really just eye candy, right? So I apologize if I insulted anybody by saying that, but from what I understood, that was correct. But I know that those are very well, very good techniques.
Yeah. Here's the other thing about Ross. He's a guy who these large firms are going to pay good money to come out and teach their associates and partners how to write. So he is very well respected. He is a known resource, and we have the ability to buy his books and follow him. And it's just going to help you write better.
I think any resource that you can take, especially right now, right? I mean, we all we're all supposed to be sheltering in place, right? Why not take a little time off your casework while you're sheltering in place? And, you can view those books as self-improvement, right? For your skill sets. And if you agree with it or disagree with it, put some thought in it, read about it, talk to other people about it, not up close and personal, but have a phone call or a web call and chat about it and decide what you think. But man, right now is just a perfect time to get, if you've wanted to read some of these books, right now is the perfect time to order them and sit down and read them.
Yeah, I agree. And these books they're just fun to read too. I mean, it's just, everybody has to write in their profession. And so honestly, even if you weren't a lawyer, you'd find his books relevant and useful.
That's excellent.
So I want to move. The next is just sort of an example of effective legal writing. This one is something I did not write. It's written by Paula Ray, excellent federal lawyer out here in Denver. And this was for a variant sentence. And I'm not going to go through it in detail, but as we look at it, she's got a good title. She tells the judge right away what she wants. And even though she does start a little bit with by and through counsel, she says, I want time served. Okay, so now the court knows she's looking for time served. Why is that? She highlights her introduction. She moves on to a brief legal analysis. And I think actually the brief legal analysis is crucial. I did a presentation on allocution in federal court. And one of the things that in sentencing motions, and one of the things that the judges said over and over again was, I know the law on sentencing, don't spend 5 pages on it. And Paula does a really good job here of giving the relevant law, and then she moves on and moves into her justification section. And you see she puts in her motion nice headings.
Right.
And then she's going to break up, like in history and character of the defendant, childhood trauma, exposure to gangs, children, age at the time of offense, drug and alcohol addictions. So she's giving bookmarks to the judge that if, for instance, like you said, the judge gets interrupted, okay, well, where was I? Well, I was at, the reasons for the variance, and I was at drug and alcohol use, right? Okay, I can go back to that. So I think Paula just does a really good job of breaking this motion up. It's not an overly long motion, but it's effective. And at the end, she concludes with she's seeking a sentence of time served. So she starts off saying what she wants, and she ends saying what she wants. And I think that's important. We do that in trials, primacy and recency. We do that. It's important to do that with a judge too, to come back to what we want. To begin
and I think repetitiveness is very important too, is to, I see that at trial. Oh, the point's been made. No, let's keep making the point a few more times. Right?
Exactly. Yeah.
Yeah, that's really short.
It was very short. She ended up being time served for a client, so it was a good outcome.
So it was a successful motion.
Right. This next motion is it's a motion that is going to incorporate pictures and headings, but I put it as a motion I wrote. And in this case, a group of clients were charged with obstruction of a federal facility, and it happened to be an ICE facility. This was back when, in the summer, when they were deporting children and putting kids, separating them from their parents. So this was a protest that went on. And the motion is to dismiss for selective enforcement and prosecution. And these are hard motions to win. The court is going to be loath to kick a case for selective prosecution. And so the idea here is that, well, we need to show the court that there were other people who were similarly situated as the people charged who didn't get charged. And I think you can write about that, and the court would probably understand it. But I think it makes a lot more impact if the court can see it. So we do a brief introduction. We have the law. And then we move to paragraph Roman numeral 2. Similarly situated individuals were not prosecuted. All right. Now we're going to move to the photographs. So the people who were prosecuted were the individuals who were sitting behind these other people, right?
Right.
This is the entrance to the building. I think everybody there would be obstructing that entrance, don't you?
Yep.
But everybody who's standing is charged.
You broke up a little bit. I'm going to ask you to repeat what you just said.
Sure. Well, the point that we're trying to make is that if you look at the picture on page 5 here of 21, all these people who are walking, who I think can reasonably said to be obstructing that entryway, they didn't get charged.
Yeah, there's one with a backpack right there that's standing right in, not walking, just standing.
Right.
There's several people standing over to the right, but it looks like a driveway that one person is standing dead center in front of.
Right. And so our point was to tell the court, well, the reason that they prosecute our clients is because our clients have a political message that they have put along these dragon tubes that lock them together. And they say sort of nasty things about ICE and the enforcement. And so if we're like, well, let's continue with the theme. Let's give more pictures. Again, we have all sorts of people walking. They don't get charged. Now, here's a picture, they're saying abolish ICE. All these people who are seated don't get charged. The people behind get charged.
Just because they have what look like those, when we were kids, what were those called? Do you know what I'm talking about? Those.
Yes, I do. Yeah. What did they call them? I know what you're talking about because you'd get your finger stuck in them.
Yeah, you'd get your finger stuck. And those tubes almost look like that except for arms. I don't know if that's what they are, but yeah, they were, I don't know what they're called.
Can't remember them either.
Yeah, my gray matter is gone, but that doesn't make sense. It looks like everybody that was in those tubes got charged and nobody else did.
Right.
I think it had to do with the tubes.
I think it did too. And then we have, page 9 here where this individual truck, well, he tried to enter the parking lot and was basically going to run people over. He doesn't get charged.
Oh, wow.
So, and the idea is that if we, flipping through, if we continue to show these pictures, well, the judge has a better idea now of what was going on. And the judge can see what it is that occurred. And now can not just say, well, you're asking me to enforce this selective prosecution remedy. I can now see it. And so he's going to look at the judge or to the prosecutor and be like, well, why weren't these other people prosecuted? What's the reasoning before that?
Now, let me go back to that for a minute. Did in the text of this, did it explain what people got charged and what people didn't, or is that something that you would circle and highlight on the pictures for the judge?
We did. In the writing, put that there was direct evidence only the protesters who used dragon tubes were arrested and currently facing prosecution. And then there was evidence in this case that they were targeting the people in the dragon tubes. And so then when you get to the end, after you go through the pictures, well, what you want in a selective prosecution motion is to get discovery to help show it. And so then, there's the need for discovery and specifically list out on page 19, 1, 2, 3, 4, what we want the judge to give us. So this judge doesn't have to wonder what it is that we're wanting. He knows what we want because we've told him specifically what he wants. And if he would have granted our motion, this case ended up in resolving without any sort of plea. But if this case would have moved to the court having to make a decision, he would have been able to cut out, 1, 2, 3, and 4, had he wanted to grant this motion and give us exactly what we wanted. This next motion.
Do they ever come back and say why?
Why we want X, Y, and Z?
No, why, if you had done this, I would have granted it. Why didn't I grant it?
That's a good question. And I don't think most judges give that kind of feedback. That's one of the real difficulties is in the practice of law is that there's a wall between the court and the lawyers. And so I think the more we can ever get a chance to get into the minds of judges is helpful because if we can understand what they want, we help our clients more. In front of you, here's a prior motion I wrote. And this is an example of a bad motion. Okay. I wrote it quickly. Had a client who was in federal custody who they wanted to move into a state court to give evidence in a pretty serious case. Well, my client was awaiting sentencing, so I'm invoking their Fifth Amendment right. And the government, the district attorney doesn't want to grant immunity. And so in Colorado, you can go to the court and say, look, this isn't right. My client has a righteous Fifth Amendment claim, and you should grant her immunity, in essence, or find that her Fifth Amendment privilege is valid. So I write this motion, and we go to the hearing, and the judge comes out, and the judge starts asking me questions, and it becomes clear that the judge she didn't understand what I'd written. And that troubled me. But, yeah. But I thought about it when I went back. I looked at this and thought, well, would I have understood what I wrote in this case? And what I noticed was, I didn't apply any of the rules that I've learned from Mr. Gruberman and other people who were good writers. I use legalese in the beginning. I don't do headings and subheadings. Everything just sort of flows into one mishmash thing of emotion. And as a result, what happened is I had to orally argue the motion and then was able to convince the judge that my client, in fact, did have a Fifth Amendment privilege. So I thought, well, I need this motion here. And so this next version is, revised and applying the rules. And
Much different look.
right. And so there's a lot of use of headings. And I think basically, if all you did was read the headings, you'd have an idea of what I want and what I'm asking for. And I think this is a much more easy to understand and readable motion. So we start off with the heading, we want to quash the writ and subpoena. We give a short background section. We move into why is my client here? Well, they want her testimony. And it's important in Colorado that you need to tell the judge we've requested immunity. So I've requested immunity. The judge knows that. Next, the district attorney is not offering it. My client is invoked. Forcing my client to testify implicates her right to remain silent. And this is crucial then for the court. Her invocation of her privilege is not speculative. So the legal standard to order my client to testify can't be met. What's the proper remedy? Quashing. And I use that as an example of trying to apply all the rules that make for better legal writing.
Very clean, not tied up with Latin. And you say twice what you want.
Right.
Once at the beginning, once at the end.
Yeah, and I think that's important. I think it's very important to understand, to help the judge understand that is what it is that you want is to ask for it more than once and to make it clear. So those are my suggestions. I'll return back to Mr. Guberman. I really encourage everybody to buy his books. The one book is from the perspective of the lawyers, and the other is a perspective of the judges. And he takes you through what is good legal writing from a lawyer's perspective and what's good legal writing from a judicial perspective.
That's terrific. And right now, again, I think that while we're sheltering in place, pretty much I think that I saw the news today, everybody but maybe 10 states aren't doing it. So that means that 40 states are, and if you're one of those 40 states, then now's the perfect time to get some of that reading ordered and actually read.
Yeah, I agree. I think it's a good chance to sort of hone up on our skills, and writing for me is something that I can always work to improve.
Well, and you make the best out of the situation that we're in, and it's a horrible, horrible situation that all of us have found ourselves in. And I'm very lucky to be sheltering with my wife and my 2 cats, and it's not high stress. I work at home anyway. I mean, it's certainly different, but it has not been high stress. But I know that for others, domestic violence has gone up exponentially right now because
that's too bad.
Yeah, it really is. And but so instead of arguing with your spouse, you go out and get these. Don't go out. Order them in, and read and hone in on legal writing or anything else that maybe needs a little bit of brushing up on. But yeah, I see just as an expert, I see a lot of motions, and again, as a scientist, I don't understand 50% of what I'm looking at. I've gotten a lot better in the last 25 years, certainly.
Yeah.
But so I think that you certainly can tell the difference between the what you've produced when you showed that, and then all of the comments from the judges that you got. I think that really gives. I hope it gives all of the people watching some insight to what judges actually want, not what you think they want, what they actually want.
Right. Yeah, I agree.
And I think that's critical in providing for your client.
Yeah, I think it is. I mean, if we want to be better advocates for our clients, we have to understand who we're writing for and how we can write best for them.
Well, that's super. I certainly, I tell you, I had to wonder a little bit about when you said that you were excited about this topic. Really? You're excited about writing? And this is somebody who, I can't write my name half the time, but, I write reports. If I do write anything, it's in a report fashion or it's an affidavit. And I was taught in college, don't write flowery,
Right.
take all of that out, state your hypothesis. You've got your abstract, then your materials and methods, and then your conclusions. And that's how we were taught to write. And I know that is so much different than the years and years in law school of all the writing instruction that you guys get that we as scientists don't get, but that's what you're inundated constantly with is how to write.
Yeah, and I think
so
that
I found this
unfortunately,
very interesting.
well, good. I'm glad. It's as lawyers, we're going to have to write. Every lawyer who, unless I can't really think of a type of law where you're not have to write. We're all going to have to write, and we can all write better, and we can all try to write better.
Do you have any other suggestions for people out there who are trying to that are maybe newer lawyers or that are trying to improve on maybe 25, 30 years of doing this? Everybody can try something different,
Yeah,
whether they're set in stone or maybe try something.
I think that just because we did it one way doesn't mean it's the best way. And I would pay attention to what the judges say, because universally the judges I talk to basically give you the same feedback.
Well, I think that if you can and the judge is open to it, I think that it would be an excellent idea, like you did, is to talk to the judges and see what they do want. And maybe you could have one person in a state talk to them,
Right. Yeah, I agree. I think most judges, I think they do want to get out the information. So I think if somebody can approach them for a CLE, they'll share. Just give them some time.
I can't see that they wouldn't want to. The judges that I have interacted with, I can't see any of them. Maybe one or two, but most of them, I would say 99.9%, want to learn, want to be educated, and want to do the right thing.
Yeah,
right?
That's right. I agree. Yeah.
And so, well, this has been very, very interesting, and I certainly thank you, Miller. And
Well, thank you.
If there's anything that you want to add, or if you need toilet paper, now's the time to ask people to send it in.
That's right. No, we're good. I appreciate you having me on, and hopefully somebody will find it useful.
Well, thank you, Miller. And I would like everybody to stay tuned for next week. We should be having some more excellent guests on Credits Without Contact. And we appreciate Tiffany Roy, who was last week, and Miller Leonard, who is right now and just shared an excellent presentation on legal writing, practical legal writing. So thank you very much, Leonard. And you're out of Golden, Colorado.
Yep.
Miller Leonard law.com, correct?
Yep.
And thank you so much. And I will speak to you after the broadcast in a little bit.
Okay. All right. Thanks so much.
Thank you. You take care.
You too. Bye-bye.